Okay, we should be live. Welcome, everyone. My name is Daniel Crane. I work for the Center for Creative Entrepreneurship. I am the Programming and Community Engagement Manager here at CCE Global, based out of 2112 Chicago. We are here providing resources for the creative sector. We do webinars, global talks, boot camps, and we're really trying to aggregate all the resources for our creative sector. So every Wednesday throughout November and December will be webinars that will kind of give our creative entrepreneurs some tips on different types of things that can help their business grow and protect their business. We also do global talks every Friday at 2 p.m. Central, and we invite different artists, creatives from different industries to kind of discuss what's going on in this current climate. How do we adapt? What are some of the tools that people are using? And it's just it's a really nice way to stay connected during the pandemic. And then we have a boot camp coming up in December with Free Spirit Media that we are really excited about. So we ask all of you to check out cceglobal.org to learn more information about that. So today we're really excited to have a 2112 member, Bill Patterson, a part of Swanson, Martin, and Bell, to talk about IP. So you have put in all the hard work to create something, to um, build something, and you need to protect that work. And Bill Patterson is all about that. Basically, he focuses on teaching you how to protect your hard work, your intellectual property, what that looks like. So what's really great is that we are going to be doing a three-part series with Bill. So this is the first one, and we're going to have one in November and December. So I encourage everybody to check that out. And if you have any questions, please comment. And without further ado, I would like to introduce Bill Patterson.
Hey everybody, how are you doing? My name is Bill Patterson. I'm a partner at Swanson, Martin, and Bell. And we're going to go through a little bit today on how to think about protecting all the work that you put into building your business. One of the biggest challenges I see when I work with entrepreneurs or other creative types is, you do the work, you need to put the work out there. It's time to make money off the work. But how do you do that without letting somebody steal your great idea? And the law really lets you do that a number of different ways, depending on the type of work it is. So what I'm going to go through today is sort of how to work with your lawyer, how to work with any lawyer, and make sure that that lawyer is protecting your work and really building value for your company. Because frankly, as you get out there, one of the things that people are going to want to know about you is, did you protect this? Are you out there and have you done the right groundwork? If you lay the right foundation for your company, to let it succeed, or have you kind of opened the floodgates and they should expect competitors to simply, steal your idea and run from there? So let's talk a little bit about how to best protect yourself. The first thing that you want to think about is, what are the real threats to my company? And, to be perfectly honest, while, China or outside threats tends to get the most publicity, the vast majority of my clients, the vast majority of the time when I'm talking to people and they've already had their intellectual property, disappear out the door, it's because of something internal happened. It's a former employee took the idea and ran with it. It's a former business partner that has had access and decided to use all that stuff. And so you really need to think about, the external threats exist, but most of the time it's an internal threat. And it doesn't mean that you need to run around afraid to share your idea with anybody. You can't do that. But you do need to think about this next question I have, which is, how do you protect your work? And as we're going to discuss, it really depends on what the type of work is. And finally, we're going to talk a lot, as I said before, about what it is that you should be asking your lawyer, what it is that really makes your work stand out. How does the business arrangement that you contemplate with your partners, with your clients, with your vendors, how does that, what kind of legal language do you need in your contracts to really, emphasize the fact that this is going to be your work product and it's going to stay with you. And just because they've been exposed to your ideas doesn't mean that they can take those ideas and run with them. So the way we're going to talk about this today is I'm actually going to work a little bit backwards. What I'm going to do is I'm going to go through two situations where clients have come to me and they've said, hey, my work's been stolen. And get ahead of myself. And what they're going to do, what we're going to do is we're going to talk about, well, what is it that was stolen and how did we already protect it? What sort of foundation have we laid to protect that work? And what we're going to really dig into is if you've laid a solid foundation, it's a lot easier on the back end to get a great result and to either claw back that work or to get compensated for the loss of that. So the first situation, I was approached a number of years ago by a client who said, hey, we've had a business partner for a number of years and they decided to break up with us. And now we're pretty sure that they just took our software and they've used it for themselves. I said, okay, let's talk about what this is and how we can protect it and where we should go from there. This is a case where we sent maybe one or two letters at the beginning, but it was pretty clear from the get-go that it was going to be all about the litigation. And I'm just going to go ahead and give you the punchline of the story. After some litigation, we were able to get a great outcome for the client. The client received in a public settlement $61 million, which is a fantastic outcome. Everybody was happy, steak dinners all around. But how do you get to that? What is it that you need to have done as a company that lets you go down that path where that's even going to be an option? Because unfortunately, I also deal with a lot of clients where, hey, somebody stole this stuff. It's like, well, did you do this? No, we never did that before. All right, now, our ability to maximize the value in this is being diminished. So the first question, though, once you get into it is, well, what was stolen? And in this case, it's software. All right. But we could apply this question to literally anything that you're doing as a creative type. Are you writing code? Are you writing music? Are you writing um, the next great novel? What is it that you're putting out there? And what you need to understand is that the law looks at your intellectual property and it puts into different buckets. And there's four buckets. There's trade secrets, there's patents, there's copyrights, and there's trademarks, and I'm going to throw trade dress kind of in there too. A trade secret is the very first thing that your company ever comes up with. On day one, I would argue that you've got a trade secret. So what's a trade secret? A trade secret is basically the thing that you know how to do that is going to let your company make money. So it can be your idea, it can be how you're going to do it, how you're going to do what everybody else has done, but you're going to do it better. It's that thing that lets you make money. Now, for the law to protect your trade secret, you have to keep it secret, and you have to, and it actually has to be something that can make you money. The next thing on this list is a patent. And for creative types, this tends to be, a less often used intellectual property protection. Patents tend to be issued for new and novel ideas or inventions. Software fits awkwardly into this. If you're doing something with software that's never been done before, it may be patent eligible. But if you're doing something that's been done before, it's just you're the first one to do it with software, that's not patent eligible. So, the devil really does exist in the details there. So when I'm working with my client that came to me and said, hey, our software was stolen, the first question is, well, is this a trade secret or is it a patent? Well, they hadn't patented it. Didn't make sense as a patent. So we can strike out patent. The next question is the copyright. You can copyright software. You can copyright a lot of different intellectual property. Songs naturally lend themselves to copyrights. But the challenge here in my particular instance with the software was that the copyrights isn't usually what's stolen, right? If you're a programmer, one of the things that you understand is that the value of just copying the code isn't really where the money is made. The value is looking at the code, understanding how something was done, and then being able to replicate it, even if you've changed the language or changed the wording or the coding, right? So copyrights can be a tricky way to protect software, a tricky way to protect tech companies, but very good for other artistic endeavors, very good for music, very good for, um, artwork, etc. Finally, we've got trademarks and trade dress, and this is another one that comes up very quickly for most companies. And, you're out there, you've got your unique brand. The name, the logo is a trademark. If you're also out there and you're creating a unique look and feel, that's trade dress. If I took all the signs away, but I blindfolded you and then dropped you into the middle of a McDonald's, as soon as I took that blindfold off, you would know it was a McDonald's. The color scheme, the furniture, the architectural furnishings, they're all distinct. You can go on the internet and you can find, the pictures of the old Pizza Huts, right? And all these different buildings that used to be Pizza Huts with the very distinctive roofs have been modified, and they're now homes and they're now office buildings. But you just look at it and that was a Pizza Hut once upon a time. That's part of trade dress. So this is all part of the brand. For creatives, this is an important thing to think about at the beginning as you're building your brand, as you're building what you are. Am I unique? Am I unique enough that I can get protection from the United States Trademark Office? But you don't necessarily have to worry about this as the thing that's going to be stolen internally. This is the one that's most likely to be stolen only by your external threats. But we will talk about trademarks in a minute. So moving forward, how do you protect this work? Well, there's a number of ways that you do that. You can enter into non-disclosure agreements. You need to enter into independent contractor and employment agreements. Once your work is ready to be sold or to be shared for money, you're looking to enter into a licensing agreement or another type of sales or resale agreement. And finally, you need to think about what's the disclosure. How widely am I sharing this information? And frankly, the first three are pretty much put in order as you start your business and you build your business up. The non-disclosure agreement is something that you really need to worry about on day one. The independent contractor agreement, employment agreements are what you need to worry about as you start adding people to the project. And the licensing agreement, it tends to be, further down the line once you've got a business deal in place. So let's talk a little bit about non-disclosure agreements. You can go and you can get on Google and you can find a bunch of these, and they do an okay job of protecting you, and they're great as long as nothing bad happens. But the reality is, this is a fairly simple document that a good lawyer ought to be able to provide for you, and they ought to be able to provide you one that's customized specifically for your needs. Now, how do you make sure it's customized for your needs? Well, there's a couple of questions I want you to ask. When you're working with a lawyer on this, you want to make sure who is this covering? Is this going to cover just me? Is this going to cover the person I'm disclosing all this information to? Is it going to cover their affiliates? Is it going to cover their lawyers? Are they going to cover their accountant? Who all is being bound by this, and how? Make sure you understand that. One of the trickier things about non-disclosure agreements is trade secrets, which is weird because trade secrets are probably the most important thing that non-disclosure agreements protect, right? You enter into a non-disclosure agreement because you want to be able to share confidential information, your trade secrets about your company without fear of them being stolen. But most non-disclosure agreements are written so that they terminate in fairly short order. A trade secret, one of the big benefits of a trade secret is that it lasts forever, or at least as long as the idea is a secret, right? So what happens when a contract terminates is the trade secret still protected. A lot of contracts fail to take care of this. I would say in 60% of the contracts that I review and mark up, I'm making this edit for my clients because it's a big glaring hole. And so what you need to do is you need to make sure you understand what the intellectual property is that you're sharing, whether you understand which bucket it goes into or not. Just know what you're going to be sharing and talk with your lawyer about, is this going to be protected? Is this going to be protected after the agreement terminates? And finally, and related to that, you need to really understand if the non-disclosure agreement really meets your business needs. Are you really protecting the right intellectual property? Are you really protecting yourself from what you're sharing? Are you really going to be able to go back and claw some of that back if you find out it's being misused? How are you going to be able to protect yourself? These are all things that you want to talk about with your lawyer as you're going through. And I want to emphasize this kind of again, but the advantage of having these things in place isn't just that you're going to protect yourself. It's also so that you're going to start building the value and the credibility of your company. Because the first thing that investors are going to look at once they start digging into your company and ask you to open up the kimono is, well, where are the non-disclosure agreements? What is in place that's going to protect my investment? How sophisticated is this person that I'm going to invest with? Are they actually protecting all the work? Are they going to protect my money? Or, are they just sort of all over the place and they share this with anyone and I'm likely to lose all my money because somebody else is just going to take these ideas? So these are very important that you get them in place. It's very important that you get them in place at the beginning. It's very important that if somebody doesn't want to do a non-disclosure agreement with you, that's fine, but you know what you will share and what you won't share. And it's very important to keep all that in mind as you go forward. So next is employment agreements, and really independent contractor agreements fit under this as well. And the number one question that you need to make sure that you're asking your lawyer or working with your lawyer through is making sure that you own the work that is being created by this employee or by this independent contractor. Is the magic language in my agreement that makes sure that everything that I do or that I pay this person for comes back and is owned by the company? The next question you want to ask is, are there additional protections that you're going to need? Do I have a confidentiality agreement in this? Most of them have it, but does it really protect you? Does it really meet your business need, right? Do I have some way of requiring this employee to assign me patentable work if they do something that can be patented during the scope of the employment? Do I have some sort of agreement that I can point to and say, hey, if I need you to sign something for the patent and trademark office saying that I own this, you will do that? Those are good things to have in place now. Same with copyrights, and especially with copyrights. A lot of work done by independent contractors. Who owns the copyright, who owns the patentable intellectual property is left too far open. So you want to make sure that you're really protecting yourself. And again, you want to make sure that these employment agreements match your business needs. There should be an open conversation with your lawyer about what you're trying to do as a company. What's the culture you're trying to build? Are you trying to build a company where you're going to own all the intellectual property? Are you trying to build a company where are you trying to build an independent contractor network where you're letting them kind of go off and do their thing and you might license their intellectual property back in the future? How are you trying to structure all this? And really, you can start to lay that groundwork in these agreements. And the other thing, frankly, lean on your lawyer is that while you're responsible for the business terms of the deal, ask your lawyer if it really makes sense, especially if you're relatively new to negotiating in your area. There's a lot of times where I'll advise clients, look, if you're going to own the intellectual property, it should be one price. And if you're not going to own the intellectual property that comes out of this agreement, it should be a different price. And we can use that to negotiate together a better business deal. So lean on your lawyer for that as well. Licensing agreements. So one of the things that I want you to really focus on when you're thinking about letting your work go out, and whether this is a reseller agreement, a licensing agreement, whatever it is that you're putting in place to share your work with the world for money, there's a couple things you need to keep in mind. One is, do I still own the work? Am I just giving this away free to everybody, or once they buy it, they own it, or do I still actually have control? Every software program that you go out and you buy, you don't actually buy, you license it, right? You don't actually have a right to the source code or to modify it or to create derivative works of that source code. That is all still owned by the software company. They just simply sell you a license to use it. Are you doing the same thing? What happens if you license a song lyric out and the client decides that they want to take it, but they want to make some modifications to it? Do you still own that derivative work? Do you still own what they've done to it? And the last question that I really want you to focus on is, well, what happens after termination? If you terminate the agreement, do you have any way of making sure that they've actually stopped using? And this is a business question as much as it is a intellectual property law question. What's the recourse? In the case that I talked about earlier, we had an audit right. We had a right to go and look and see what our partner was doing. And find out if they were continuing to use our software or they were not. Now, certainly they insisted that they were not using our software, and in that case, they agreed to discuss the use of the software or what they had done instead with us. And that discussion simply led to more questions and not enough answers. So, litigation ensued. But you need to understand, are you going to have that opportunity to try and figure out what's going on, and how is that going to happen? Because the worst situation you can be in is sitting there thinking, I think they use my intellectual property, but I can't prove it, and I'm never actually going to know, because that just leaves the entire world sort of unresolved for you, and it makes the gamble on whether or not you're going to find out through litigation much higher. So again, getting information, what is the information you're going to be able to get back as to what happened? And the other thing is, there may be derivative works, there may be additional intellectual property that's been developed through the course of the arrangement. Thinking about who's going to own what afterwards will simplify your life immensely. So you want to think about that as well. Um, I more or less covered this, but the final thought that I want to leave you with is that you need to make sure that these agreements cover your business needs. And the trick to this is always explain more about your business, more about what's going on, what you're trying to accomplish than you might otherwise think is necessary. And the reason for that is that your lawyer, if you've got a good one, is going to be able to incorporate those goals into the license agreement and help you achieve those more readily. One of the big issues I see um, with, especially when I take over the work products that others have done, is that they've checked all the boxes. It's more or less protecting the client, but it's really not helping the client achieve their business ends, because they've thrown in these restrictions on how the intellectual property can be used, or they've been more focused on trying to get the best possible deal for their client, and less focused on how do I get my client what they actually want. And then you end up in this awkward situation where you're sort of trying to rework the deal to benefit yourself, make it more consistent with your goals, but also, you know, without wanting to give up too much more to the other side later on. So it puts you in a real jam. When I work with my clients and we talk through what it is that the deal actually needs to do, how they're going to make money, how we're going to minimize their downside risk on this deal, make sure we're all together on that. It helps us streamline the document, and it also helps us work together as a team to figure out how we're going to maximize the value of these agreements for you, because then I can help you negotiate for the terms that you really need, and help us give a little bit in exchange for giving a little bit more on terms that we don't maybe necessarily need. Disclosures. Now, especially when this is intellectual property is taken, this becomes a huge issue. And one of the big issues is, well, was this the knowledge, was this know-how disseminated on a need-to-know basis? For trade secrets, this is very important. You need to think about, and frankly, your company's confidential information. You need to think about who's going to have access to this. Do they really need access? And how am I limiting those disclosures? When you disclose it outside the company, is it always under an agreement? Is there always an NDA in place? And this does not just matter for litigation. This matters immensely for valuation of your company, for outside investors when they're coming in and trying to understand, is this something, is it secure? Am I investing in something that is likely to be taken away soon? Or am I investing in something that the owners have really taken the time to really understand how to protect themselves and thus protect me and my investment? One of the easy things you can do, mark documents that contain confidential information as confidential. Is this a legal, cure-all for big mistakes or bad documentation? No, it's really not. You should be careful of that. But it helps. It does make a difference when you mark confidential documents as confidential, especially when you're disclosing them outside the company, because it lets others know that this is confidential information. Remember, we signed that NDA, and this is the confidential stuff I was talking about. And we don't want you going and running around using it and sharing it with our competitors. So those sort of reminders that you've entered into these agreements and we need to follow those terms of those agreements become very, very important. So before I get into external threats, let's sum up the internal issues that we see. In my case that I'm talking about, we had a client. The client, sorry, the client knew that their intellectual property had been taken. Their intellectual property, or at least they strongly suspected the intellectual property had been taken. The intellectual property was a trade secret. We figured that out. And then we worked through, were all the NDAs in place? Yes. Was there confidentiality in all the employment agreements? Yes. Was there confidentiality in all the licensing agreements? Yes. In that case, it was a reseller agreement with our business partner. They were out there reselling. Did we have confidentiality that extended to the partners that they were reselling to? Yes, we did. So because that strong foundation had been built, there was value there in pursuing the litigation. Similarly, with the external threats, there's really only one big change. And the big change between an external threat, a company that's outside your partnership network, is it's a much different question about trade secrets. You very rarely have an external threat take a trade secret. And the reason is you've probably done enough to protect that trade secret. Or if you haven't, maybe it wasn't a trade secret in the first place. It's very rare, the headline situation where you have somebody hacked into your computer systems, stole your trade secrets, and now they're using them. I just don't see that happening very often compared to everything else. But have a good computer system, and I don't want that to be lost today. More likely, the content that you've created is out there, it's being freely disseminated because that's the type of content that you've created, and somebody decides to copy it or somebody tries to emulate it. And we see this with intellectual property that can be patented. We see this with intellectual property that can be copyrighted. We see this with intellectual property that can be trademarked. Very recently, I had a company come to me and they said, Bill, we've had our intellectual property stolen. Okay, well, what is it? Well, actually, it's our name. All right, well, did you register the trademark? No, we didn't register the trademark. All right, well, that's going to be a challenge. But what are they doing? Well, they're using our name to sell the product. Okay, fine. We can do with this. And you start working through the problem again. So let's talk a little bit about what it is that you do to be proactive, and then what it is that you can do on the back end when somebody decides to copy your great idea. So let's talk a little bit about what's a patent. As I referenced earlier, a patent is your license issued by the federal government to exclusively make, use, or sell an invention. You must register it within 1 year of inventing this new idea. And that's an important thing to keep in mind, especially for small companies, because registering in a patent can be very expensive. So if you want to go for it, you need to go for it. The flip side is a patent is very valuable. It's an exclusive license to do it. Investors like it if you have patents because they know that those can always be resold if in a bankruptcy situation. So it's a quick way to show you're creative, unique, and you've got a brand new idea. And the final thing about patents last for 17 years. So let's talk about this in the creative context. For software, it really only works if you can point to something that you're doing with your software that's never been done before. What it doesn't let you do is it doesn't let you patent, I'm doing this with software, even though we've always done this before. I represented a client not too long ago who was using QR codes on their advertising. There's somebody with a patent for using QR codes or for generating QR codes. The patent's not valid. And I want you to be aware of this because it's a little bit of an issue. 6-7 years ago, the Supreme Court issued what's called the Alice decision. And in the Alice decision, they really restricted what kind of software could be patented. And it's important for 2 reasons. One, you should know it's harder to get software patented now than it used to be. But 2, you very well may be in a situation where you've got an idea, you think it's a great idea, and somebody comes to you and says, "Oh, you can't do that without licensing it to me because it's patented." They say that, check with a lawyer, because a lot of software patents aren't valid anymore. And yet we still have a cottage industry of people saying, "Oh, you need to pay me a $50,000 license, and I'll go away and I'll let you do the thing that you're doing." Consult with a lawyer. It's going to cost you less than $50,000 to find out what they think of the situation and whether or not you should pay this license fee. Um, Frankly, it feels like 3, 4, 5 times a year I have a client reach out, and you look at the patent, and most recently, quite frankly, we looked at the patent, we realized the patent had expired. So there's bad actors out there that you just need to be careful of. The patent lasts 17 years. It's a great protection for your company if you can get it. What's a copyright? A copyright is probably the most used tool for intellectual property protection of artists. It's the exclusive right to print, publish, perform, film, or record literary, artistic, or musical material. Software can be copyrighted. I'm personally not a huge fan of using that as a means of protecting your software, although there's a time and a place for everything. And a copyright lasts a very long time. It lasts for your life plus 70 years. The big advantage of both patents and copyrights over a trade secret is a trade secret can't be, or a patent and a copyright, you can look at it, you can copy it, and that's breaking the law. If you've got a trade secret, if your company has a trade secret, and I look at what it is and I figure out my own way of doing it, that's not breaking the law. I'm allowed to do that. A classic trade secret is the Coca-Cola recipe. If I taste Coke and I read the ingredients off of it, and then I put together my own recipe to make Coke, um, nothing really Coca-Cola can do about it. It's their trade secret, but I copied it. If they had a patent on that recipe, then they would have told the whole world. And if I created my own Coke using the same recipe, they would be able to sue me, but only for 17 years. So, there's a trade-off there. For artists, one of the great things about copyrights is they're really not that expensive. Work with your lawyer to figure out what it is that you should get the copyright on, what the splits are between the different creators of the material, and you can get it done, but it really shouldn't be particularly expensive. Patents there's just no good, cheap way to do it right. Copyrights can be handled much more quickly. So in a lot of ways, it's a better protection, especially for artists and other creatives. What's a trademark? A trademark is a symbol, a word, or words that represent your company or product. You go and you register your trademark, but there's a little bit of a caveat. And the caveat is really who owns the trademark comes down to who was the first person to use the mark. So in my example with the client who said, "Hey, my trademark's being used by a competitor to sell my products, but we haven't registered it." Well, the good news is we've been using the mark for 50 years. So we could go and we could get a registration with the Patent and Trademark Office, and we had the superior right to use that name. You do need to continue to use it, is really the only catch. Once you stop using a mark, you abandon the mark and somebody else can pick it up. But as long as you're continuously using that for your brand to sell your services, that's your trademark, whether or not you've registered it. It's better to register it, however. And there's a couple of reasons. One, it's not expensive. It's actually, I think, a little bit less expensive than a copyright. And typically, depending on a few variables, but it's in the same ballpark. It's fairly inexpensive. And the big advantage of getting that registration is now you've put the whole world on notice that you own this one, and it makes it less likely that other creatives, other entrepreneurs will move towards the same thing. We see a lot of, for better or for worse, we see a lot of hurting in the market where, I'll date myself with these examples, but everybody wanted to do like the e-commerce or eBay or and just put E in front of some sort of word. when you get that trend going, it's good to get out there and get the first mark on it, because then you're sort of creating some room around yourself. Make sure that nobody else is doing it, nobody else is copying your work. And really, it's a lot easier to go out there and know on the front end whether you can or can't do something than simply start. This is a great, frankly, this is a great way to try and get to know your lawyer and figure out if you've got a helpful lawyer or not. A good lawyer in these situations is going to help you with your create your brand. They're going to say, look, here's, we've got your idea. We ran with it. We ran it through the database at the Patent and Trademark Office. It's probably a little too close to this. It's a little bit different than that. But, if we make a couple of changes like this or a couple of changes like that, it could work. No, that's an answer you're looking for. Um, you're looking for that sort of advice. Now, we're not creatives, and there's a reason that we practice law, right? And it's because we don't think like you do. But if you find a lawyer who can at least kind of point you in the right direction and help you be creative in a way that avoids challenges later on, that's a lawyer worth keeping. Licensing agreements. So you're going to license your patents. You're going to license your copyrights. You can license your trademarks. When you enter into those, you need to make sure you understand the purpose of the agreement. Why am I working with a lawyer to draw this up? What is it that we're protecting, and what is it that the lawyer is going to help me accomplish with my goal? And once have your goal in mind, make sure you're saying, hey, lawyer, my goal with this licensing agreement is that they can use the copyright for this, my song for this amount of time, limited to these situations, and they can't change it or modify it at all. Okay, great. Those are things that the lawyer is going to write into the agreement for you. And then make sure you understand where that is in the agreement. There's no, when you're working with your lawyer, especially about these things, there's no dumb question. Feel free to ask. Make sure you understand these agreements. They're written in very obtuse language. It's not the easiest language to work through. I get it. So just ask, hey, where's the sentence that protects me from X? Whatever your concern is. It's always a great question. Let's talk about enforcing your rights. So my client whose competitor was using their trademark, what do you want to do? Well, the first thing you want to do is make sure that there you go again. Make sure that your competitor's on notice that they've violated your rights. The reason is pretty straightforward. Once they're on notice, the law allows for significantly increased damages. And these significantly increased damages really ratchet up the stakes of litigation, and frankly make it less likely that you will be dragged down into protracted litigation. The notice can be provided through a cease and desist letter. There's a million examples of those on the internet. A good lawyer will be able to draft you one relatively quickly. They are fairly basic in what they're going to say. They're going to say, hey, you're violating our trademark rights. That's a violation of this part of the federal code. Knock it off. The letter itself is important because it puts the other side on notice. It also hopefully creates the first instance where you're able to talk back and forth about what's going on. The real trick with the notice and the cease and desist on the internet is that oftentimes those are put into the terms of use. If you have a problem with Amazon, for example, they've got a form that you've got to go through and fill out. There's actually an art to filling out those forms, and they can be very, very frustrating. For artists with a lot, many of you have become accustomed, unfortunately, to using those forms and figuring out how to go through. Otherwise, a lot of law firms have access to we'll give you access to our paralegals who can work with you on that at a much lower rate to help you work through those issues and really make sure that you've got a successful appeal, or put the company on notice successfully that they're infringing your work. Hopefully it lends itself to a takedown very quickly. Often in situations, somebody will disagree with you. And they'll say, no, I think we're allowed to use this. It can go one of two ways. One, you can work out some sort of licensing or a coexistence agreement, especially with trademarks. Okay, I'm using Pete's for grocery stores, you're using Pete's to sell shoes. Um, I'll agree that as long as you use Pete's to sell shoes and not food, you can use the name, and I will agree to sell food but not shoes, and you'll let me use the name. That's a classic example of a coexistence agreement. You kind of agree to use to boundaries. You can also license the work. Somebody can say, "Hey, I'm really sorry. Yeah, we shouldn't have used it. Please don't sue us. We would like to continue using the work. Can we work out a license?" It's a great situation. It's a great opportunity. It can be a great opportunity for you to build your business, build your brand, if it's good publicity for you. Um, that's actually another very common fact pattern for me, dealing with especially creative clients. It's, hey, I put this thing up on YouTube, and now Disney is using it. What do we do about this? Well, do you want Disney to keep using it? Yeah, I just want to get paid. Okay, great. You know, we can work towards a licensing agreement and get you properly compensated for your hard work. Um, the other option is litigation. And the thing about litigation that I always tell clients is litigation is really negotiating a business agreement through the courts, because the vast majority of commercial litigation ends up through a settlement, not through trial. And so, if you're unable to work out some other deal, if you're unable to be properly compensated, then litigation becomes, a very valid option. There's a lot of things that you want to talk about with your client or with your lawyer, as you go into litigation. And one of the things that you should be very clear on is what the costs are and what the upsides are, and why that particular project fits with your business needs. Do you need to spend the money because you need to protect your intellectual property? The first client that I referenced that ended up with a large settlement, they had three reasons that they wanted to go into the litigation. One, their stuff had been stolen, and they were motivated to see justice be done. Two, they thought that they were going to want investors in the future, and they thought that if they showed investors that they would go to the mat to protect their intellectual property, that would increase the value of the company. And third is that they knew the software was valuable, and in fact, when it ended up selling for $61 million, they were able to turn around to investors and say, "See, look, the software is very valuable. The market, our competitor just valued it at that and paid us that, for their access to it." So there's multiple reasons. It's going to change based on what your business is and what it is that you care about. But there can be very good reasons for getting into litigation. And so, don't just sit back and say, "Well, I'm a business. That's not what I do." There are situations where, the way to further your business is going to be through the courts. They're not common. I want to be really clear about that. They're not particularly common, but they are situations that come up, and there are situations where that's necessary. More often, thankfully, it's, "Hey, bad thing happened. Can we work out another deal without getting involved in litigation?" And oftentimes, especially when you have a good lawyer and when your opposition has a good lawyer, that's how things work out. Um, so let's go through how to work with your lawyer and really, what the questions are that you should be asking. Share with your lawyer what you have. Lawyers have a duty, an ethical obligation to keep all of our conversations with you confidential. So share with them what it is that you have. Share what it is that you've developed, and listen to their feedback on how you can protect it. If I don't know that you've written a song, I don't know to tell you that we need to go get a copyright. If I don't know that you're working on a new brand and you're about to roll it out, I can't advise you on whether or not it's going to infringe on somebody else's trademark, or if you're going to be able to get your own trademark for it. So, keep us up to date on what's going on. In your mind, though, you should always be thinking about, well, how does all of this benefit my business? How does this benefit my goals of what it is that I want to see achieved? I want to grow. I want this product to be nationally renowned as the go-to thing. How do I make that happen? And then how does this agreement help me make that happen? It's a business question, but it's also a legal question. And so work with your lawyer to make sure you understand that. And like I said earlier, the better I understand as your lawyer what your business goals are, the better I can help you negotiate through the document and get better terms. Always think about how you're covered after the contract ends. I know it's exciting, it's wonderful. You've got an agreement with somebody, they're going to help you make more money. You're focused on the making the more money now, but it's going to end someday. And so make sure you think through when that relationship ends, how am I going to make sure that I'm walking away with the intellectual property, with the hard work that I put in? How am I going to make sure that I retain that? How am I going to make sure that I retain what I've paid for? If you're hiring independent contractors, how am I going to retain, my hard work? How am I going to make sure that just from their exposure to my hard work, they aren't able to just duplicate my hard work? Think those things through. Um, think about how, as you grow, how are these agreements going to need to be changed? How are they going to need to be updated? Think about policies and procedures. I know it sounds crazy when you're starting off and it's you and a friend and you're putting together the company, but someday you're going to have 10, 20, 30 employees. You may need an employee handbook. You may need policies and procedures in place. One of the things that you need to be thinking through immediately is, in this virtual environment, what is it that my employees can and can't do? Are there, um, video conferencing platforms, for example, that we're not going to let people use because they don't really protect our information very well? This can become very relevant very quickly for you. So, think through what the processes are, what, how people should communicate, what are the proper means? Are they protected? Are they going to protect your intellectual property? And the most important question that I think you should always come back to is, how does this create value for my company? Because taking all these steps and working with a lawyer properly makes your company more valuable by highlighting that, one, when you work with another business partner, they know you're serious, because you're taking these steps. And two, when you're working with investors, they also know that you're serious about protecting their investment. You want to really think through, how does this build my company? How am I laying the foundation to make this thing successful? So at this point, I'm going to open this up for questions. I think Daniel's been following the chat. Um, excuse me. He'll let you know, or he can send anything to me. If you have anything for me, um, you think of it later or anything like that, it's my phone number, my email. I'm looking forward to talking to you, or or anyone else at Swanson Martin Bell is happy to help you as well. Thank you very much.
That was great, Bill. Thank you so much. Um, so I think what really struck me with this conversation is, people who are on the creative path do not think about um, some of the things that you talked about, in terms of, hey, you can help someone create their brand, right? You can take a look at what they're providing, and what they have, and say, here's how you should set it up, right? So I also think it's really important that you're focusing on how this makes your company, your creative, your art more valuable, right? How can you set up your business um, to be successful? And as somebody that was an independent musician for 15 years, it's really important, I think, for the creative community, to be asking these questions early on. So, Bill, when do you think is the right time? Let's say someone wrote a play. When do you think it's the right time for them to talk to a lawyer? Kind of about how to put this out into the world. How do I protect my work? What's the right time for you?
For me, the right time is right. If you've written a play or creative piece, it's right before you're ready to put it out to the world.
Mm.
um, there's not a ton of risk before you start sharing it. As long as it's on your computer and you're not putting it out there. But once you go out to publishers or others that might consider the piece, at that point it's worth having the conversation. Find a lawyer that will talk to you for an hour about the right things to do, A lot of us will do that, for free or at a very minimal cost, because what we want, frankly, is from our end, we want the relationship. A good lawyer knows that you're just growing this thing, and the last thing that we want to do as a good lawyer is kill the thing for you because we charged you too much money on the front end. We'd rather see the thing grow, and then now we've got a relationship and we can grow with you. Is going to be the approach that a good lawyer will take in those situations. But you want to get in, or you do want to get in before you share it. If you're a company, um, I think the best time probably is basically as soon as you're starting to come up with a name, um, or at least a name and a brand. And there's no harm in saying, okay, I'm going to be 264 LLC until I really figure out what it is I want to do. That's fine. But once you start kind of going down the path of I want to be, this company, I'm going to call it Apple. That's a good time to have a conversation with a lawyer about whether or not that's really a great name for your software company. Probably not.
Right.
So, but before you really start making that investment, save yourself some money and make sure it's a path worth going down.
Yeah, I think you also brought up something that was interesting as well, and that the creative world doesn't think about, right? So we are we are creating, maybe LLCs to protect our bands or our theaters or our dance companies, right? But how do you set it up so you can, so an investor can be excited or feel safe about investing into your entity, right? So, you brought up, I think, some important points of, hey, if an investor comes and you have your work protected, and you have things kind of set up, they can relax more, or they feel like they're more. Can you talk a little bit more about that?
Sure. So let's talk a little bit about the investment process.
Mm-hmm.
You're going to go out to an investor and you're going to say, I've got this awesome thing. We're going to make awesome amounts of money. And the investors
Mm-hmm.
are excited about it. And they're going to say, well, what do you need me for? It's like, well, I can make even more money if I had your money. And it's going to help me do X, Y, and Z with it. Great. Everybody's loving it. Everybody's excited about it, right? Now the investor is going to say, well, do you own this thing that I'm
Mm-hmm.
investing in? And what is in business, you go to business school, they talk about this thing called the moat. What's the moat between your castle and everybody else that keeps them outside, and how big is your moat? And so they're looking at, do you have the NDAs in place? Do you have good licensing agreements in place that protects your creative work from anybody else just copying it? Have you gone out and gotten copyrights on it yet? What am I investing in? Now, in a lot of situations, especially if you're getting investment very, very early on, maybe part of the term is deal is, hey, I need some money for, to go get these albums copyright, get the copyrights on all these albums. Or I need the money to go get a copyright on this and that. It's not that expensive. I hope you're not in that situation because we're really talking about a few $100 to get these things done. But it could be, in which case just front it. It's fine. Um, but the investor is going to be looking at that and they're going to say, well, what am I investing in? How big is this moat? How protected is the work that they've done from everybody else trying to steal their stuff? Because they know that once you're making money hand over fist, everybody else is going to want to do the thing you're doing,
Right.
and you want to keep them away.
Yeah. Yeah. Well, thanks, Bill. I think this is, we're really excited to have you, as a part of this series, and to let everyone know out there that Bill is going to do two more of these. And this will live live on our YouTube channel and our Facebook channel. We'll reshare it. I think these are really important questions and answers for our creative entrepreneurs out there. I think one thing that you really touched upon is we need to be thinking about, IP from the beginning of your work. And it's better to ask an expert or a lawyer who can really break down all of the different options and kind of what you should be thinking about as you're developing your business. So again, my name is Daniel Crane. I am the program and community engagement manager here at CCE Global out of 2112 Chicago. We're very excited to be providing our creatives resources for growing your business. So we were going to be hosting webinars like this one with Bill on Wednesdays in November and December. We have a boot camp coming up at the end of December with Free Spirit Media. And then every Friday, we do our Global Talk series with the director of the Center for Creative Entrepreneurship, Saudia Davis. We bring in different people from different creative sectors and kind of talk about the current climate and issues that are going on right now. And it's a really relaxed, nice hang that you can learn a lot from. So those happen every Friday at 2 p.m. live on Facebook and on YouTube. But again, thank you, Bill, for just getting this started. We are really looking forward to the next two in November and December. Check the schedule at cceglobal.org. We hope everyone has a wonderful day. Thanks again and take care. Thanks, Bill.
Bye. Thanks.